Oral Presentation for Defamation by Maroulis. Some brief facts of the case. Claudine Ransom has now become the new Prime Minister of Australia. Claudine's no longer able to run the business that she was involved in with her husband Ronald, which was a property development and retail business. Her son-in-law Kerry Gonaway has now taken over that responsibility of running the business with Ronald. Ronald and Kerry have now become directors of Stud Proprietary Limited, and they're about to launch a line of new men's fragrances and underwear. More Than Media, an online news website, they've made suggestions and also commented about Ronald and the new venture of Stud on their website. More Than Media don't have any corporate presence in Australia, and all of their servers are located outside of the country. The questions that need to be answered is firstly, can Ronald, Kerry and Stud establish the necessary criteria that is needed to successfully sue More Than Media for defamation? And secondly, will the Australian law apply, given that More Than Media have no Australian corporate presence and all their servers are located outside of Australia? Some relevant principles of law that are applicable in this case is firstly the definition of defamation is provided in the Palmer and Coupland case, and it states that the publication of matter which lowers a person's reputation in the eyes of others by bringing them into hatred, contempt or ridicule. A more recent definition has been provided by Lord Atkin in the Simmons Stretch case, where it was stated that a defamatory statement is one which tends to lower him or her in the esteem of right-thinking members of society generally. Another relevant law that is applicable is from the Goddard and James case, which provides that only an individual can bring an action for defamation and not a group. Now, to succeed in an action of defamation, the plaintiff has to establish three elements. The first being that the material is defamatory matter. Second, the defamatory matter referred to or identified the plaintiff. And third, that the defamatory matter was published. So step one is the material defamatory matter. Section 4 of the Defamation Act provides the definition of matter. Very wide definition, but can basically be summarised as any form of communication to a person, whether that be written, a picture, a gesture, or an oral utterance, would all be satisfactory to satisfy the definition. Second thing that needs to happen is to determine was the matter defamatory. For it to be defamatory, it must injure a person's reputation in the eyes of others. So this is a two-step process to first find out what was actually communicated, and then secondly to determine if that communication could be considered defamatory. So the common law tests that the courts will use to determine if matter can be considered defamatory is firstly in the Palmer and Coupland case, which provides that the matter will be considered defamatory if it exposes the plaintiff to hatred, contempt or ridicule and is likely to injure their reputation. Second, the Simmons Stretch case is that would the matter lower the plaintiff in the estimation of other right-minded members of society. Thirdly, that the matter causes the plaintiff to be shunned or avoided by other people and has the capability of being classified as defamatory. It's provided in the Yusupov case. And fourthly, in the Sungravure case, that the defamatory matter is directed to the trade or business of the plaintiff and has an effect on the personal reputation. Now further to this, the defamatory matter must lower the reputation of the plaintiff and not the business reputation. Otherwise, the correct action would be injurious falsehood and not defamation. The second element for a defamation action to be successful is that the defamatory matter has to have referred to or identified the plaintiff. The Knopfler and London Express newspaper case provides that the plaintiff must show that the defamatory matter is about them. Doesn't need to be expressly identified, only that people that could identify the plaintiff from the publication. It's provided in the Nixon case, and the consolidated trust case is another authority that identification can be indirect, and it states that it's not necessary for the plaintiff to be expressly identified, only that people with knowledge of the plaintiff would be able to understand that the defamatory matter was referring to them. The third element is that the defamatory matter has to have been published. Now, the Dow Jones case provides that publication, online publication that is, occurs when defamatory matter has been communicated to a third party. And being internet material, the courts determined that material, if not comprehensible, until it is downloaded. And so where it is downloaded is the correct jurisdiction for publication. The Zwambilla case also provides that for international publications, the correct jurisdiction is where the plaintiff is known and has a reputation. Another thing that needs to be considered in this case is that a corporation under Section 9 of the Defamation Act cannot sue for defamation unless they can prove that they are an excluded corporation. Excluded corporation is provided in Section 9.2 of the Act. First requirement is that the corporation does not include financial gain for its members. So a non-for-profit organisation would fulfil that criteria. Second criteria is that they must employ less than 10 people and not be related to another corporation. If a person publishes defamatory material, even if they're not the original author, may be as liable as the authors. The authority for that is provided in the Truth and Holloway case. And again, only an individual can sue for defamation. They must show that the material and defamatory matter was reasonably referable to them. So in this situation, we need to consider each cause of action individually. If we look at applying the law to Ronald's situation, the first step is to determine the defamatory matter. As stated before, matter can be an oral utterance, which can be a form of communication. The suggestions made on the website were that Ronald, prior to marrying Claudine, used to be a male stripper. So if we go to the second step, of what was the defamatory matter, the express imputation that can be drawn from that is that Ronald was a male stripper. Now, if that could be considered to be defamatory, because it could expose Ronald to hatred, ridicule, or contempt, or cause him to be shunned or avoided by people. So, given that, Ronald would most likely satisfy this first element regarding the defamatory matter. Second thing that needs to be established for Ronald is that he was identified. He'll have to show that the communication was about him. And because there was a direct reference made about Ronald regarding him by name directly and about referring to his previous history of his life, so this element wouldn't be difficult for Ronald to satisfy either. Publication regarding Ronald, as is stated in the Dow Jones case, that publication occurs where content is downloaded, and for international publications that would be where the plaintiff resides and has a reputation. So being that Claudine is a new Prime Minister, Claudine and Ronald would most likely live in Canberra, which is in Australia. So because M&M, more the media, have a wide online readership, it is highly likely that people in Australia would have had that defamatory matter communicated to them, and Ronald is well known in Australia, so in this situation the Australian law would apply. If we look at Kerry's situation, and applying the law to him with regards to defamatory matter. The statement published on the M&M website by the authors is a form of communication, being that it has actually been published and is in written form, so the definition of matter would easily be satisfied. So by looking at what was the matter defamatory, we can draw a couple of imputations from this. The express imputation is that Stud has the potential of making a substantial amount of money due to the prior reputation of the Ransom brand. The implied implication that can be drawn is that Stud is in a position to exploit Claudine's new position of power as Prime Minister, which will put him in a position that most people are not able to do. So the question that needs to be asked with regards to the imputations is, could they be considered defamatory? In this situation, most likely not. By applying the tests that would determine if it's defamatory, they probably couldn't be considered defamatory. Kerry might be able to argue that the matter injured his professional reputation, as provided in the Song of Your case. To do this, though, Kerry would have to show that the defamatory matter reflected on his personal character and reputation, and in this situation is not very likely to be successful. So Kerry's going to find it difficult to draw any imputations out of the statements made on the website that would be considered defamatory. With regards to identification, as was said before, identification can be indirect, as long as it can be referenced back to the plaintiff. There is a relationship between Stud and the Ransom brand, but Kerry is going to find it very difficult to show that the defamatory matter made reference to him. So it's unlikely that Kerry is going to be able to satisfy this element. Publication is determined on where the plaintiff has a reputation or lives, and as was previously determined with Ronald's situation, the content or communication of the content has been to a third party and it has been downloaded, so this element would not be difficult for Kerry to establish. As far as Stud Proprietary Limited, as was stated before, the company, to pursue an action of defamation, must be an excluded company. So the criteria that needs to be fulfilled to determine that. Now the first step in section 9 part 2 part A, the fact that they're selling men's fragrances and underwear would most likely be considered as a merchandising company, most likely with the aim of making a profit. So they're not going to be able to satisfy this requirement very easily. We haven't been given the amount of employees in the case study, but the fact that the Ransom brand is related to Stud Proprietary Limited would also show that this element would not be able to be satisfied either. So the fact that Stud would not be classed as an excluded corporation would mean that they would not be able to pursue a defamation action. So in conclusion, looking at Ronald, he has a good chance of successfully pursuing a defamation action towards More Than Media. Kerry is going to find it difficult to satisfy the required elements, and is most likely to be unsuccessful if he did pursue a defamation action against More Than Media. Stud Proprietary Limited, as has been said previously, would not be able to be classified as an excluded company, and therefore they would not be able to pursue a defamation action. Thank you.